Good morning, everyone. Thank you all for joining our Government Commission on Disability for this webinar. Today, we are going to be talking about disability rights and different types of workers and how to treat non-traditional workers. And we'll have Marissa DeMaya as well as Diego DeMaya from the Southwest ADA Center. Before I turn it over to them, I do want to go over some housekeeping for this presentation. So you have access to interpreters. You can access them by clicking on the button, and you can also access captions and have any comments through the Q&A. Our chat is disabled through Zoom, which means that for any questions for the presenters, you will use the Q&A tool, and we will try to be sure to answer them towards the end of the webinar. After this webinar is over, you'll have an optional survey to give us feedback. We always do appreciate your feedback to know how we can improve. And we will be sending that email to you all later if you want to complete the survey. This email will also include an access link to our webpage so you can see this recording, the PowerPoint, and other resources that we have available. And now we will turn it over to Marissa and Diego.
Hello, greetings. Thank you all so much for inviting us to be here. My name is Marissa DeMaya, and I'm with the Southwest ADA Center. I'll also introduce my colleague, Diego DeMaya. Diego, say hello.
Greetings and hello to everyone out there. This is Diego with Diego de Maya with the ADA Center.
You might notice our last names are the same. Diego is
Oh
my
yeah, they
older
are.
brother. He's my older brother. We just happened to land on the same project years ago, and it's been a pleasure all this time. So I'll get that out of the way. Um, Very quickly, we just wanted to do a shameless plug about us. The Southwest ADA Center is one of 10 centers across the United States that is federally funded to provide you with information. We serve a wide array of audiences, all related to the Americans with Disabilities Act. And our mission is basically to just educate and inform the public about your rights, or in some instances, obligations under the Americans with Disabilities Act. And we have a toll-free line that we respond to. We have staff like Diego and myself who answer that line. It is available for anybody to call. All calls are confidential. So we encourage you, if there is a question today that we don't get to, we always want to encourage people to give us a call on the toll-free line. And I will put it in the chat, but it's also at the end of our presentation, we've included that information, and it is 1-800-949-4232 in case anybody does want to reach out and talk to us offline. That being said, next slide, please. All right, I'm just going to dive right in. Today, we're going to talk about the vast legal protections provided by the ADA of all things, and also Section 504 of the Rehabilitation Act. We're going to touch briefly on these as, we have a little bit of limited time, but we're going to try to get to everything, hopefully, that encompasses the vast legal protections, as I mentioned. All forms of paid or unpaid workers, including employees, temporary employees, seasonal workers, volunteers, of course. And also that includes undocumented or migrant workers, contractors or subcontractors. All, these classes are protected from disability discrimination by a variety of state and federal laws. Now, this includes, the various titles under the ADA, specifically Titles 1, 2, and 3. As I mentioned, Section 504 of the Rehabilitation Act, And the Fair Labor Standards Act, or FLSA, the National Labor Relations Act, which encompasses union organizing, actual unions and protections or protected work activity, if you will. OSHA, which is the Occupational Safety Rules Standards, and of course, the EEOC, which is the Equal Employment Opportunity Commission, enforcement guidance on contingent workers. So as you can see, we've got a variety of, state and federal based equivalence protections here. I'm going to move on to the next slide, please. So what types of workers, as I mentioned, does this protect? We kind of ran through the gamut just a moment ago, but again, paid employees, full or part-time, temporary or seasonal workers, staffing agencies and placement agencies, undocumented or migrant workers, as I mentioned, and paid or unpaid interns. This is case by case. Volunteers, partly under ADA Titles 2 and 3, have broader coverage under Section 504. And here we've thrown up just kind of a variety of photos, just a little bit illustrating what we've mentioned here. Is we've got in the first photo, we've got an African American lady in a wheelchair. She's working in like a warehouse environment. She's dressed in a brown uniform. Then we have another lady who is working in a hospital, and she's wearing a blue hospital vest and some carrying some linens coming out of like a linen closet. Then we've got a couple of workers that are like construction or warehouse type workers, one of whom is in a wheelchair and they're appearing to converse. And then we've got a photo of the outline of a worker plowing like a field amid a sunset. Just to kind of give you an idea, we've thrown in some photos there. Next slide, please. So diving in, paid temporary and seasonal workers. These are covered as employees under Title I of the ADA. The duration of work for temporary, seasonal, or undocumented status is really irrelevant. And that's a point that we will probably bring across many times throughout our presentation today. Anyone is entitled, or all really entitled, to Title I protections of the ADA, which is the central protection that covers employment rights, to reasonable accommodations, the interactive process, and we'll get into that a little bit more. And we've thrown up there the basic section of the information that depicts the ADA. Diego, jump in anytime here. I feel like I'm talking a lot, but
You're doing great so far.
All right.
It's good that we get through some of these pretty straightforward things, and then we'll get to some of the more, more complex relationships. Go ahead.
Absolutely.
Yeah.
And we have thrown up another illustration up here with a little help wanted sign depicting seasonal workers, help wanted with a little snowman and a little Christmas tree. And then we've got our photo from previous slide of the migrant worker. All right, next slide, please. All right, staffing agencies and joint employers. Again, joint employer doctrine would apply here. And basically, what that means is that placement agencies or staffing agencies, the host employers are typically liable, right, per Title I of the ADA and 504, Section 504 of the Rehabilitation Act. What this means is they'll focus on factors such as the extent of control, for example, of the employment environment. So while the placement or staffing agency controls the employee, as a third party or second party, right? They're contracting with the employer. So there are a couple of different layers here, or various layers, if you will, with regards to how this applies. But, you know, the extent of the control would focus on the environment that the employee's in and who's hosting that environment,
Yeah, and
essentially.
let me add this to that. The idea here for everyone to get is that in most cases, I'm going to say, 95% of the cases where you have an employment agency, a temp agency, a placement agency that is providing temporary workers or temporary employees, um, in most cases, they are placing actual employees who get paid hourly. They might even get paid, by salary. They might even get paid by gig, by job, but they are considered employees, and so they are protected under the ADA. And Section 504, just a quick reminder, remember that Section 504 applies in situations where, and there's a slide that mentions this later, but it just basically it's when any kind of employer gets any federal funding for any reason. Like a good example is school districts. They get federal funding. Colleges, universities get federal funding. So a lot of people working there end up getting paid through federal funds, like grants. Grants is a good example. I mean, there's millions of dollars in grants that come into different entities and institutions. But going back to joint employer liability, what you got is basically you got two employers, and they are both responsible. They both have the liability for ADA protections and compliance. So they both have to comply. So when an employee says, so when a temp employee going to an agency says, "Oh, I have a disability and I need a reasonable accommodation," the the job of the temp agency is not to ignore that and say, "Oh, well, you have to go get that with the employer. We don't deal with that." That would be the wrong answer from the temp agency. The temp agency has to be entirely involved in the process, and they have to facilitate that interactive process, right? We'll get more into that. They facilitate the interactive process between the employer, the agency, and the employee to process that requested accommodation. So make sure that you understand that joint employer liability means that they're both equally responsible for what happens. Now, a lot of agencies have agreements, and that is legal. They can do that. Um, but essentially, even if a contract between an employer, let's say like a state employer, let's say that they hire temp through a temp agency. Um, Even if they have a contract that says the employer shall provide all accommodations and respect all civil rights related accommodations like religious accommodations, pregnancy related accommodations, disability accommodations. Even though there's not contract language in there, the temp agency remains liable under the ADA. In other words, they don't exempt themselves by contracts. All right, Marissa, go ahead and move on.
Thanks, Diego. And just FYI, we've thrown up a little illustration up there too of a person. It's just a brief graphic of a young woman with dark hair seated at a laptop. She's in a wheelchair and she's working at her desk amid a little bit of a blue background. We also have provided a link here to that Diego's included to EEOC guidance on contingent workers. You will receive a copy of this presentation so you can have access to all the things that we've hot linked in this presentation afterwards. So don't have to rush to take notes. I know. All right. Next slide, please. So, as we mentioned earlier, immigration status is irrelevant. And here we've thrown up a little illustration of the US American flag. Immigration status or absence of a work permit doesn't exempt employers from anti discrimination laws. And that is, a point that we will um, bring across throughout our presentation. But we do get this question quite a bit at the ADA Center.
Yeah, quite a
Um,
bit.
Lately it seems to be circulating a little bit more often than not. So we did want to stress that, but the Equal Employment Opportunity Commission enforces those protections against discrimination. And
Yeah,
that
and I want to,
includes, go ahead.
no, go ahead, Marissa, finish up. Sorry.
Oh, no, that's okay. That includes, as we mentioned, based on race, color, national origin,
Right, right.
sex, religion, disability. Go ahead, Diego.
Yeah, so is that national origin statute, that under the Civil Rights Act that protects, anybody from any country, it doesn't matter where they're from. And the idea is that the United States is an environment where people have certain rights that they retain the minute they set foot inside the country, regardless of activity, as long as it's legal, as long as it's lawful, right? And so the tense, right, the tension here is that a lot of people, and I'm going to say it because it's not that I'm trying to be politically incorrect, but a lot of employers regrettably believe that if they hire somebody who's undocumented, they will not have to honor their rights, or they can pay them below minimum wages, and so on and so forth. And we've all heard the stories about this. We've seen headlines. There's nothing new here that I'm mentioning. Um, it's a big country with thousands and thousands of employers, and it happens. I think it happens in every country, by the way, no matter where you go or where you live. And so the idea is that if something bad happens to a worker, just because they're undocumented, that doesn't mean that they just get thrown to the curb and abandoned and left alone. So that this is what that's about. The other thing I want to mention, which was very much, I reminded myself, and it actually surprised me because I had kind of forgotten about this. Um, the IRS, the Internal Revenue Service, has a legal procedure where any undocumented or immigrant worker without a work permit can request an EIN, an employee identification number, or employer identification number. They have different names for this. And of course, the laws have changed and the names and the titles change. But basically, what you're looking at is they can assign a temporary, sort of like SSN number. It kind of looks the same, so that that worker can file income tax returns. Okay, folks, let's keep that straight, that a lot of people who are working without a work permit are actually filing income tax returns on a yearly basis because the IRS requires everybody in the country. They don't they don't tell a difference. They're not selective about who files. It just says anybody who makes any money from wages shall file income taxes, basically. And so they do that. And what happens is that because undocumented folks cannot apply for, I repeat that, they cannot apply for disability benefits, like SSDI, SSI. They cannot apply for retirement benefits. I repeat that, they cannot apply for retirement benefits. They're not qualified under the Social Security statutes and regulations because the difference is that under those statutes, they are required to have um, work permits or be working in the country legally under some kind of legal status. So just kind of wanted to throw this in there because a lot of people very erroneously believe that these kinds of workers are not protected, and they actually are very much protected under the FLSA, the OSHA rules, the ADA, Section 504, so on and so forth. So I'll stop here and let Marissa continue.
Thanks, Diego. Next slide, please. So, changing gears a little bit to interns and trainees. And we get this question quite a bit as well with regards to, paid internships or unpaid internships.
Oh, yeah.
Uh, Either way, paid or unpaid, interns are considered covered employees. So unpaid interns might also be covered under like Titles 2 and 3 and Section 504 per special affiliations or programs. I'm trying to think of some examples here. Diego but
Well, paid.
volunteer. Go ahead.
Yeah, yeah. So the thing to keep in mind about interns and trainees, right? Very important in this country because we have huge internships and trainee programs all over, and they're very important because that's how people get experience. So they're extremely important. But what's happened in the past couple of decades is that there's been some litigation about what's considered a paid intern versus an unpaid intern, and are unpaid interns considered employees, right? And the way that this turns is that, believe it or not, a lot of the lawsuits have been against law firms that take unpaid interns from law school and basically have them do the grunt work, right? By the way, I'm a lawyer, so here I am criticizing lawyers. Um, they take unpaid interns and they make them do a lot of the grunt work. Sure, they're not going to be doing litigation work or like really important things like legally advising clients and whatnot, but they do a lot of the writing work and research work, stuff like that, kind of like what paralegals do. And it was questioned. And some people decided, I'm going to I don't feel like I should be an unpaid worker when I'm doing all this grunt work. And so it went to court. And also, it went to court based on disability issues because they were not being accommodated. Unpaid workers, unpaid interns were not being accommodated. And I apologize to the closed captioning people for talking so fast. I'll try to be a little more eloquent. Um, so unpaid workers basically said, feel like I should be protected under the ADA, and essentially they went to court. And the way it turns is like this: if it's strictly an educational experience, and please, folks, don't try to remember this. You can look the stuff up, okay? We didn't put it up there because we felt that it just was too superfluous, too much stuff. Um, but basically, it turns on whether the experience is educational, only educational, and the unpaid intern basically just gets to kind of like, what's the word I want to use? Coast. They kind of like they hang out in the environment, they're exposed, they go on rotation with the lawyers, they get taken to court hearings, they get to watch the litigation process, they can watch the lawyers do all the counseling with the clients and all of that, all under strict supervision, under confidentiality and so on. And so they said, well, that's an educational type of thing, so therefore, no, they're not a paid employee. And so they will be protected under, for example, under Title 3 of the ADA, and we'll get to that shortly. They will be protected under Title 3 of the ADA, where the internship or unpaid internship cannot impose discriminatory terms against the unpaid intern. In other words, if an unpaid intern in a wheelchair comes in and they say, "Oh, we don't want a wheelchair person here," they can't do that just because they're a volunteer, because they're unpaid, because they're an unpaid intern. The ADA Title III, which applies to, right, applies to private businesses like law firms, they would protect the Title III would protect the rights of the unpaid intern. Go ahead and move on, Marissa.
Okay. And we've thrown up a couple of photos again there. We've got our young lady who is working as a hospital volunteer. We've also got a couple of ladies there in another photo that one lady appears to be showing the other how to work a type of kiosk at a hospital setting. All right. Next slide, please. So volunteers, that kind of segued us into that. And as of course we've mentioned briefly before, volunteers are covered as employees. They may be partly protected if they receive significant remuneration, if you will, or benefits, right? Redefining them as an employee or possibly an independent contractor. And again, as Diego mentioned, that would fall under Titles 2 and 3 that would likely cover them as a program participant, if you will.
Right.
Also, Section 504, right? That would likely cover them as a program participant if it's federally funded or a funded program like that.
So, by the way, by significant, what's the word they use? Remuneration? Is that what they
Yep,
used? Yeah.
remuneration.
Yeah. What they mean by that is basically like a huge bonus, like, like, I don't know, like suppose you're a volunteer and suppose you're selling stuff for a nonprofit, for example. Suppose it's art. Suppose it's expensive things that people donate for the foundation, right? See, the organizations, the foundation has to be really careful here because even though the person selling, right? And think about this for a minute, right? A volunteer could be a professional, a highly skilled, highly experienced, possibly maybe even retired ex or former, high-tech salesperson who is so good at what they do that they are now, doing volunteer work for this foundation. And all of a sudden, they are doing stuff for this foundation that's bringing them millions. And the foundation decides to give them a bonus, like, I don't know, $100,000. That's what
Wouldn't
they
that be
mean.
nice?
Right. That's what they mean by significant remuneration. It has to be significant before the law says, hey, this person is an employee or a contractor. So go ahead and move on.
Okay. And here we've thrown up a little photo of it for as an example as a volunteer. We've got a couple of a lady in an apron they're like in a cafeteria setting, and we have a young African American man wearing a matching blue type uniform shirt, and she's showing him how to make dumplings. Again, this is just a brief example that we threw in there. Next slide, please. Section 504 coverage, as we touched on earlier, again, we're just reiterating here, it applies to federally funded programs, including Title I covered employers, Titles 2 and 3 covered entities. For example, employees, as we mentioned, paid under federal grants. And it also covers those participants and beneficiaries, as we mentioned, interns, volunteers, it provides broader than employment only protections, as Diego talked about just a minute ago. And we threw in here a link to a court case, Alexander versus Choate from 1985. We've hot linked it. So again, you will have access to that later on after our program. Diego, do you want to comment before we move on?
No, no, go ahead and keep going. This is pretty clear, I
Okay.
think.
Next slide, please. So again, we've got some broad coverage examples of non-employees here, and we've thrown in a photo of a couple of workers or volunteer workers at a work site. They're both wearing bright green work vests, and they are handing off supplies or materials that they're stacking in large piles outside of some type of volunteer environment here. Um, Basically, Titles 2, right? We've talked about public entity programs, right? City volunteer programs, perhaps. Um, ADA parking monitors or ushers or hosts at public events. Voting poll workers. Title 3, again, your public accommodation activities. Perhaps, as someone mentioned, maybe there's, like nonprofit shelters, things like Big Brothers and Sisters, as an example, or the Red Cross. These are, they might have volunteer worker placement agencies. So these would fall under that broad coverage. And then there might be some other, examples of unpaid internships. Sometimes you have externships, court mandate community service. That could also be a good example. And as we mentioned, earlier, things like hospital volunteers or high school vocational programs, even. What we're been, hearing a little bit more about too, also would be things like apprenticeships, because we're seeing
Mhm.
a lot of those types of programs that are now emerging. Next slide, please.
So before you touch on this next slide,
Yeah.
Marissa, I just want to mention that in regards to court mandated community service,
Yes.
you don't have to go back to the previous slide. It's okay. Just let me kind of mention this.
Yes.
Essentially, we get calls about this because Title II of the ADA, as everyone knows, applies to the local and state courts. And what's happened is that courts often will um, get into an agreement with a litigant who takes, like a plea bargain or something, and they end up doing community service like roadside cleanup and other services that they might volunteer to go do as part of the community service. They actually might even be volunteering for an organization like Goodwill, Red Cross, local shelters, and so forth. So there's all kinds of programs that the courts are affiliated with. And that is what I wanted to mention. That affiliation, right, makes the court responsible for accommodating people with disabilities who are under a community service requirement or obligation mandated by the court. So I just kind of wanted to throw that in there because a lot of people, including judges, often think that once they assign the community service requirement, they're like, I don't care where you go, you go deal with it, just bring me back the certification letter that you met your community service time. Well, that's great, except that some community service organizations feel that they don't have to accommodate people with disabilities coming through the courts. And so now you have this tension build up in terms of who is responsible, right? So here we go with that sort of joint liability, idea. It's not to be confused with the joint liability doctrine that applies between employers and like temp agencies. This is more about the relationship between the state, the local court, and the entity that is providing the volunteer opportunity for community service, serving a community service sentence. So kind of keep that in mind because these relationships can get kind of complex because people call us and go, well, who do I get sign language interpreting from? I'm between a court and this shelter organization. And we have to explain that they are both obligated. So, in other words, Title II court is obligated and Title III shelter is obligated. And they will have to come together and meet at some point and discuss how they're going to handle people with disabilities who need, particular types of accommodations. Okay, go ahead, Marissa.
All right. Thanks. That was a great point. Independent contractors. We've also mentioned this briefly before, but independent contractor, again, it's an individual who, as a matter of economic reality, is in business for themselves, rather than economically dependent on that hiring entity. So they're not technically employees,
Hmm.
and they're not covered by the Fair Labor Standards Act, or the wage and hour protections,
Right,
not protected by the ADA in the employment context.
correct.
But the status is based on the actual working conditions. So, not job titles or an actual contract. You want to elaborate a little bit more?
Yeah, just basically what that means, folks, is that there may not even be a contract. It might be a handshake agreement between the employer and the contractor, That happens a lot. It actually does, believe it or not, with even with large employers, it happens a lot. For some reason, somebody who's look should be looking into this, with a magnifying glass doesn't. They kind of look the other way or they don't pay attention. And now you have somebody working for an organization, whether private or state, and they show up to get paid, and all of a sudden they're told, "Oh, we're only going to pay you half of what we promised we're going to pay you," and that's when it ends up in court. Or the individual might have a disability for which they want an accommodation, and the organization says, "No, we don't have to provide that. You're not a covered employee, so you're not protected under the ADA." And it's not that I'm trying to be blunt and cold about it. I mean, it's just that these issues really do come up, and these things have all gone to court at one point or another. Go ahead, Marissa.
Yeah, and before we move on to the next slide, we've thrown up just a picture up there of some workmen, if you will, in orange vests and hats, and they're paving a road, basically. So next slide, please.
Yeah, by the way, a lot of states, a lot of localities, actually, cities, towns, have gotten sued by road construction workers and their representatives or their attorneys because the city basically treated them as contractors and essentially did not provide certain benefits and privileges that employees would otherwise receive if they were considered employees of the city or the town. And so they've gone to court on that. And that does include accommodations for disabilities. Because again, the city decided, yeah, we don't need to accommodate you because you're a contractor. So if you don't like it, you can leave. Well, no, it doesn't work that way, because again, you got these relationships that are formed, whether, whether they want to recognize them or not, they've been formed. And so this had happened quite a bit. There have been quite a lot of lawsuits brought against cities and towns because of the way that they contract labor. Go ahead, Marissa.
Yeah, and we've thrown up here in this slide about contract determining factors. Diego already touched on this just a moment
Hmm.
ago, but we've got a picture up here also of a gentleman in a wheelchair who is working from a home office environment. He's typing away or tapping away at a laptop, and he's got his own computer set up, et cetera. And we put that up here just to kind of drive the point home. Contractors, they control how they perform the work. Whether it's, their, remote work environment, and they're providing their own tools, right? Their own printer, their own laptop, their own internet access. So that's just a kind of an example we can throw in here. But they invest in their own tools or the business. They can market their services to multiple clients. It's not dependent, right, on a third party or an individual employer necessarily. And they lack employer provided benefits, right? Wage protections, and in civil rights employment protections. And I think we're going to start on this. We're going to get to this in the next slides. But one of the things we've put in here is for you to review what's known as an economic realities test. And we've linked that in there. Next slide, please.
Yeah, I think it's the next one.
Yes.
Hmm.
So the economic realities test, to touch on it briefly, it's a judicial doctrine, right, that determines whether a worker qualifies as an employee, and thus would be protected by the civil rights laws like the ADA. Or if not, instead, an independent contractor or non-employee, for example, again, unpaid interns or volunteers. And the test really focuses on the substance of the working relationship. So there's no label assigned by the parties. Next slide, please. So, what do you ask in that economic realities test? Basic questions would be, is the worker economically dependent on the employer, that is, or the business for themselves? If they are economically dependent, then they're likely an employee. So
Hmm.
they, for example, they rely on the employment provided supervision, tools, workplace amenities, and benefits. An example might be somebody who could be an independent contractor, but they go or they report to maybe a home office location, possibly, on a weekly basis or a periodic basis. And so they check in and they go to that office and they use those tools that is provided within that environment by, who they're doing the work for.
Yeah, call centers are a prime example. They get sued all the time because they hire people to do phone calls or answer the phone and provide technical support, and they like to call them contractors, because I mean, it's a reality. They don't want to pay them benefits. They don't want to give them certain privileges that employees would have, whether hourly paid or salaried, and they call them contractors. And then they they entice them to accept that relationship by saying, "Well, you get a bonus. If you sell 10 widgets this month, you'll get your bonus," And that's great. It's allowed, it's legal. The problem is that when civil rights issues come up, like disability discrimination or disability retaliation or disability related wrongful terminations. When these things happen or when they ask for an accommodation, they are told, no, you're a contractor, so we don't have to help you with that. Well, they've gone to court. And basically, what the courts have found is that most of these types of jobs are actual employees because the employer controls the entire relationship. They tell the employee what to do. They provide the tools, they provide the work environment, they provide the phones, the computers. It's hard. It's it's a difficult thing to say that they're a contractor because they're not the employee, the worker is not providing anything that's costing them any money. They're just showing up to work 9 to 5. And that's another consideration, the hours they work, the shift, the scheduling, and that's how they are, and that's how this is determined, is through that economic realities test. Go ahead, Marissa. Let's go on.
Yeah, and next slide, please. Before we move on, Diego, we get a question quite a bit that's pretty common. I'd like to touch on is that if someone is working in that type of relationship, but say, for example, they are doing work for maybe a Title II entity, a public entity, where that work requires them to log into maybe a database or whatever they're logging into that is government provided, would that trigger that coverage, Diego, so to speak?
Well,
It's
the logging
complicated.
in, yeah, no, the logging in part is typically applicable to any kind of program, whether it's a volunteer program, an intern program, paid or unpaid, or employees, right? Everybody has to log in through some kind of clocking mechanism. And I don't mean like literally clocking in, right? I'm talking about the fact that you have to log your hours if you're going to get the credit for them. And that's certainly a huge function of volunteering because volunteering, um, a lot of the fundraising that takes place for nonprofits is to show that they have an X number of volunteering hours showing on their books, and that's how they are able to justify themselves as nonprofits and their tax status and so on. So that's not really going to determine, how they clock in, how they log in is not going to determine uh,
that
the
that that trigger of
the
responsibility.
relationship. No. It's just not going to determine that. What
Okay.
will determine that is the type, is the substance. I like the way you said it. It's the substance of the relationship and how it works and what they're supposed to do, whether they're getting paid, unpaid, are they getting a bonus? Is it merely for educational purposes, like I mentioned earlier, where all the intern is doing is just watching and experiencing, but they are not being made to work, right? They're just kind of like there
Maybe
and oh,
shadowing.
yeah, they're shadowing. They might be typing up a paper that they're working on that they were assigned, but they're not really working. They're not producing something for the employer or the organization. They're just there. So um, again, it's the nature of the relationship that counts. That's it.
Right. And we've thrown up here in this next slide here, the ADA generally prohibits discrimination in various relationships. So we've put some descriptions in here. I think we've touched on them fairly just about everything
Yeah.
previously, but vendor contracts or other affiliation agreements, that's one we like to often mention. As Diego talked about, again, selling goods or services, or to the public entity or business. And again, participating in a program or opportunity that's open to the public, right?
Hmm.
Opportunities to contract or perform services or sell goods. Again, examples might be, you know, venue ticket sales or usher programs. Maybe some like, for example, we often have folks that participate through the local arts right here. They serve as ushers in some of those programs. Um, Uber drivers, that's another example. Office cleaners or maintenance work or other type of gig work. So we just kind of threw that in here. Next slide, please. All right, discriminatory contract terms that violate the ADA. Again, both Titles 2 and 3 prohibit that type of discrimination in the terms, conditions, and privileges that are being offered to the public. And again, covered entities should not, may not include disability, not should not, but may not include disability-based exclusions or restrictions in contracts. For example, refusing to contract with someone because they have a disability. It's a very valid thing. We hear about that quite often at the ADA Center.
Yeah. Yeah.
Or maybe imposing extra fees on a contractor with a disability, requiring medical documentation that may not be required of others
Hmm.
if they are
Hmm.
trying to, take part in a certain type of program. Denying reasonable modifications to policies when that might be necessary to, for equal access. That's a big one. And then failing to facilitate effective communication during negotiations or the implementation of a contract.
Right. There you
Another
go.
big one. We hear
Hmm.
about that often.
Hmm.
Next slide, please.
So what applies there? Kind of quizzing people out there. It's Title 3 of the ADA, right? Because contracts between private entities and individuals, right? It's going to be Title 3 of the ADA that prohibits discrimination in those terms and conditions in the contract. One time I had a question that kind of stumped me, and I had to kind of sit down and think about it for a minute. And that was a question that related to doctors. How do doctors work for a hospital, right? And it's really interesting because doctors are typically not considered employees, believe it or not. Now, some doctors, yes, are actual employees of the hospital, like what they call the what they call the hospitalist, right? A hospitalist is typically an MD, a doctor, fully licensed doctor that just works for the hospital. And I think most people in the audience probably have experienced meeting one or two of those. They are there when you're staying at the hospital after a surgery or whatnot and recovering. And you're in the hospital room, and this doctor comes in that you never met before. That is the hospitalist, and that doctor is basically overseeing all the functions of care and medications, and basically they're the supervisor doctor over all the nursing staff and technicians and everything else, right? That's apart from a specialist that might come in to see you after your operation. So the hospitalist, and the question was, well, are they protected and how are they protected? I mean, and of course, it took me a minute because I thought doctors, wait a minute. Okay, so what are they exactly? And then it just kind of dawned on me, right? They're contractors. They are working under a contract agreement with the hospital. And for that agreement, they get certain privileges. They get a particular kind of pay, could be salary pay, could be a calculated hourly pay. It could be many ways of paying people. It could be based on how many um, how many patients they saw for in a 30-day period. You know, the point being that there's all of these different kinds of special agreements, and I hate to say it this way. It seems like they're always trying to get away with some kind of fast one, you know, some left curve that where you have to sit down and go, hang on a minute, wait a minute, hang on, and then you realize, oh, okay, it's a contract, it's an agreement, and under the ADA, they cannot discriminate. The terms of the contract and agreement cannot be discriminatory. So this became a huge lawsuit a long time ago, went to court, and the decision it had to do with the doctor had been punished, had been disciplined by the medical committee of the hospital, and had been disciplined for some kind of bad behavior. I don't recall what it was. And oh yeah, it was disability related, yes. And they decided, I think it was mental health related, Marissa, and they excluded him as part of the disciplinary action. Yeah, I saw the timing count there.
I
I'll
was
make it
just going to
short.
interrupt you.
Yeah, I'll make it short. Basically, what it ended up being is that they had excluded this doctor from participating in certain activities and privileges that doctors got to participate in, and they based it entirely on his mental health situation. And of course, that was prohibited by the ADA. I'll leave it there.
All right. So I think we've got about 10 minutes to go, but briefly, we've thrown up here the legal defenses to decline accommodations.
Very important. Yeah,
Very
yeah,
important. The
yeah,
interactive process is still required no matter
yeah.
what.
Hmm.
Whenever somebody makes a request for an accommodation or a modification, including effective communication. Undue hardship or undue burden and fundamental alteration defenses, those are all available. They are valid things, and we certainly acknowledge that. However, it's got to be business necessity. Um, they have to include, otherwise qualified. There's direct threat defenses to consider, for example, if something is going to affect the safety or health of others, right? Those are valid things, but it does take quite a bit of uh, burden, I guess, if you will, on the employer. They better have a really good reason and means or way of showing how this is going to affect them and create that
Right.
defense, that
Right.
undue
And
hardship, if you will.
right. And remember, what we're talking about here by defenses is that this is where any kind of entity gets to decline a requested accommodations, to say no, we're not going to provide that accommodation because, and then you got these defenses available. They don't go away. They're always there. And there have been situations where a volunteer has, for example, posed a direct threat to I don't know, think of a hospital volunteer posing a direct threat to patients. For example, the volunteer came to work and they had a very contagious condition and they were removed immediately from the work environment, right? That's a direct threat. And they have scientific, tangible grounds to justify that. The right at that point, it's discriminatory because of the condition, but they have a right to do it because otherwise other people will be harmed. So that's the example. But just to remind that the defenses are always available, right? But if they're going to say no to an accommodation, they just have to have a really good reason, a legitimate, good reason. And then ultimately, as the bottom of the slide indicates, ultimately, they must consider any possible alternative accommodations that may have not been considered.
It doesn't get them out of that obligation.
Right.
Great. That's the best point.
Yeah.
All right. I know we have a couple of minutes to go. So
Mhm.
I'm going to ask if they can advance us. We've we've put in a compliance checklist in here for employers and staffing agencies. We'll let you guys read that because that's pretty
Yeah.
self-explanatory, and we've gone through it thoroughly. If you could take us back down to the second to last slide, which is the high legal risk areas. It's a couple of slides down. I'm going to stop there and we're going to take a couple of questions
Yes, go
before
ahead.
we close out. Um, you know, First question we have is, does the law say anything about what employers can say to the employee? Such as, is there a protection against derogatory comments to an employee?
Uh, well, I mean, derogatory comments are going to be discriminatory if that's what they mean. I mean, if they're going to be insulting people or offending people in some way or
Or
another,
perhaps
or
harassment?
well, we could include bullying, harassment, could be anything, retaliation, isolation from meetings, segregation from whatever the activities are. Derogatory language, I mean, it depends on what situation is. But remember that a lot of the courts have allowed a great deal of bullying, and they said that's just not discriminatory enough to justify suing somebody or winning a lawsuit. Things like you know, uh, I don't know, stop being so annoying. We don't have time for that now, right? That would not be enough to um, to blame an employer and to hold them liable under some kind of a law. It has to violate a law, and that would be harassment, which has a legal definition. We're not going to get into that here,
Call
but
us.
right, call us. Harassment has a legal definition, so there has to be harassment, retaliation, which is strictly prohibited by most laws, including the ADA, um, wrongful terminations, and all of that. But language by itself may not be enough. Okay, go ahead.
Yeah, and the important thing we want to mention too is document the behavior.
Yes.
Send emails, create a paper trail somehow.
Yeah, voice your complaint,
Yeah, voice your
like in
complaint.
an
If
email.
something that someone has said has offended someone, then
Yeah.
it's important to try to document that. And you can go back after discussions, whether they occur in the hallway or at the water cooler or in a meeting, go back after your meeting or whatever the event that occurred and
Mhm.
send an email to that individual and perhaps, including those
Well,
in charge,
or to a
to
higher level.
acknowledge,
Yeah.
to the
Yeah.
higher level,
Yeah.
acknowledging the what happened, the who, what, where, when.
Mhm.
So we're going to move on, but we do want you to call us if you want to discuss that a bit further, because certainly there's so many ways that can go. Um, the next question is, how many cases have gone to court that have ruled in favor of the employee, volunteer, or intern? Diego, do you have an idea?
No, there's no way to know. I mean, no, the law firms are the ones who conduct these kinds of surveys. So you might need to Google that and do some searches to see if there's been any surveys done. But honestly, all these cases, everything we talked about has gone to court at one point or another, going as far back as the 1930s. Okay. So don't be shocked. I mean, everything has been litigated. Yeah, there's always a novel issue like with artificial intelligence. We're getting some really new novel issues now in employment discrimination. So keep that in mind. Let's move on to the next question.
All right. I think we're actually done with questions. Someone's asking
Okay,
for a copy of the presentation. We will certainly share that with you, and we've
sure.
shared that with our friends at the Governor's Committee. So certainly we'll be happy to share that again. Question popped up. Thank you. Does the number of employees matter for placed workers versus employers? Great question.
For what workers?
So they're asking, does the number of
Yeah,
employees
yeah.
matter for place workers versus employers? So for example, for maybe a staffing agency, I hope I'm interpreting that
Place. I
correctly.
wasn't getting what the place was. Okay.
Yeah.
Yeah. Under the ADA, Title 1, the employer must have 15 or more employees, 1 5, 15 or more employees to be covered by the ADA. If it's under 15 employees, the employer has no legal obligation to accommodate an employee with a disability or hire them for that matter. So please keep that in mind. That is part of the statute. Um, the EEOC might consider a complaint for an employer that has less than 15 employees. So I always encourage people to file their charges and complaints because you never know.
Yes.
The employee might decide to actually investigate and help out and help
Um,
settle a situation.
Next slide, please. We've
Yeah.
put we've put some references here. I know a couple of people were asking about cases there, so I hope you're okay, Diego.
Yeah, but I want to
Um,
mention, but Marissa, let me say something about the cases.
we have a
Folks,
minute to go.
yeah, folks, don't focus on the cases. I mean, you're going to find thousands upon thousands of cases you can read. The problem with cases is that they are very fact specific. And so when you apply cases, the idea is to extract like the judicial doctrines, um, the economics realities test, that comes from the courts. And you read multiple cases to extract that test, that economic realities test. I mean, that's how you use court cases. If you want to use them as examples to show someone that the discrimination is illegal, sure, that works too. But remember, they're very, very fact specific. In other words, they apply to that particular set of employees or that one individual, that one employee. Okay.
All right, and we are at time. If you could take us to the last slide. I want to just say thank you to Matthew for putting this all together and for inviting us. Thank you to our friends, Matthew and the Governor's Committee, for inviting us to be here today. We do encourage you to reach out to us. I know there might be one more question there we didn't get to, so please call us. All calls are confidential. You can also email us too if you would rather do that. We do respond to all kinds of inquiries. Give us a call with your question and we'll be happy to go through it more in depth. We're no strangers to training. We jump on the phone and do conference calls with organizations and businesses all the time. So please, we encourage you to reach out to us if you do have additional questions. We hope this was helpful. Thank you again so much for inviting us. And
Thank
thank
you,
you for
guys.
joining us.
Everybody have a great
Thank
day.
you.